Good morning, Mr. Gonzalez. Do you speak English?
Yes, sir.
Good morning.
Morning.
You're charged with two cases. You're charged with evading arrest and resisting arrest. You're facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description on the call slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid detainment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer. The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes before he was detained.
What was he doing wrong? All you said he matched a call slip. So
Yes, for a criminal mischief in progress, Your Honor.
that's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Then none of that. I mean, who's writing the reports? Mickey Mouse? You know, I mean, really? I haven't heard anything. I'm going to find no probable cause. Mr. Gonzalez, be careful, man.
Okay.
When you get into a pissing match with people who have the power of arrest, who's going to win?
I'm gonna be more careful. I promise it's not gonna happen anymore.
Be
I
careful.
promise. I got my family. I want to,
Okay,
Thank you.
Got it.
God bless you.
dude. All right. Good morning, Mr. Walker. So, with us, you were charged with failure to identify oneself. That's why you're charged here with us, failure to ID, right? You're facing up to 6 months in jail and or a $2,000 fine. The reason that we're taking you into custody now is because you have 2 felony warrants for, it looks like you were on probation for a felony theft, and they filed, I guess, a motion to revoke because of that warrants issued. So that's why we have you in custody now. I can't let you go because then I would get in trouble. We're going to do probable cause in our case. You have the right to remain silent. Anything you say can and will be used against you. Well, I don't want to talk about the case. You've got a lawyer. You know, you need to talk to him, let him talk to me, because I don't want you to say something that hurts you anymore.
Yeah.
So let's just do probable cause, because I don't know why. I don't even know why we're here.
Yeah, my son, I'm a single father. He like machine, everything. It's no way to put on GPS. Like,
Hold on, let's do probable
Just
cause
try to-
first,
I
because
know.
Okay.
Okay. GPS.
It's not up to him. We're just talking about these meetings.
I can't, there's nothing I can do on the felony case, man. I'm just a lowly misdemeanor.
In his defense, Judge, the felony motion is based on technicals, and in this new case, this failure to ID,
Really?
yeah, I don't see anything.
Well, let's do it real quick and then we can talk and I can give you more info.
On March 21st, 2025, officers were dispatched to a family disturbance call for service at 2525 Holsworth Road in Spring, Harris County, Texas, which is an apartment complex. The officer began by identifying the defendant, who could not provide a valid driver's license. The defendant verbally identified himself as Adam Mitchell with a date of birth of December 23rd, 1987. The reportee then gave the officers his correct name, and the defendant then admitted to providing false information due to it. Advising about a traffic warrant that he believed he had. The defendant then gave his correct name. The officers discovered an active warrant for the defendant out of Cook County, though there was no extradition.
So there was a warrant out of Cook County.
There was, but there was no extradition.
Cook County, Illinois?
Yeah, sure. I looked at the NCIC. All I saw in there that it could possibly be was some sort of like traffic offense.
Okay.
That's all the he's talking about. Don't say.
Not right. So he gives the name of Adam.
Adam Mitchell. And Judge, this isn't filed as a fugitive, just a straight failure ID.
Right. Well, because he wasn't. Well, maybe he was. I don't know. Regardless, so Mr. Walker, I'm going to find that there's sufficient probable cause. Well, hold on. I'm going to find that there's sufficient probable cause to go forward in this failure to ID case. It looks
Just
like,
call the police.
I don't want to call the police. They never asked me my name.
I don't,
Like, I'm the person who called the police.
was this, I thought it was a stop.
No, they were
No.
dispatched to a family disturbance at an apartment complex. The officer arrives, proceeds to try to identify both individuals. Began by identifying the defendant, who could not provide a valid driver's license. The defendant then identified himself verbally as Adam Mitchell with the date of birth of December 23rd, 1987.
I mean, I get that you call the police, but nevertheless, I mean, we've got,
Then he told them the right info.
but you still gave the wrong info and then they looked them up and then it gets, you know? So, I mean, there's enough probable cause to go forward.
Why would that didn't happen, but why did, like, if I call the police, why are they asking for my ID in the first place? They don't have the right to do that, sir.
They're going there for a disturbance.
Yeah,
They
because
have to,
how-
look, I can't get into that, all that stuff now. But they're going to investigate something that happened. There's a disturbance. They go there. Normally what officers do is they have to look at everybody who's there to determine, hey, who is this? What's going on here? Does this person have any kind of issues? And so, you know, regardless, the good news is that it looks like on your motion to revoke, the only thing is fees that I see in this case. Okay. I can't let you go at this time because this is a felony warrant. You're set at no bond now, but you'll get to felony court on Monday. And at that point, I mean, I'm sure that they'll do something. I'm not gonna, you know,
That's crazy, man. I called the police.
I'm not gonna,
A couple fighting, and I just called the police. That's all I did, sir. I seen two couples fighting, and I called the police because there was a guy hitting a woman.
I can't give you legal advice.
She's writing everything down too that you're saying. Maybe later
Just
down the
don't
road,
say
you might
anything at
want to
this
say
point.
something
You
different.
can talk to Mr. Pons. I'm not putting any conditions on your bond. Just be careful, Mr. Walker. Okay, thanks.
What was our bond? And this one, it's PR bond, right?
Yeah, he's got a PR.
No, I bought that for $1,000 on job.
So you're.
That's
Was it
right.
a-
Judge, it's 1,000.
Excuse me, Your Honor, I'm approaching on Neil White.
Is it?
And Judge, he's been carried like since Monday, the 24th. That's when he appeared on your docket initially for a new charge for the bond violation report, which is filed, and also a motion to revoke and raise. But he was still incarcerated on Monday, Judge, Monday morning.
He's right here now, right?
He's here now.
Okay.
But
Come up, Mr. White.
Mr. White.
We're on bond for an assault of a family member.
Yes, sir.
Since 2023.
Yes, sir.
In 2025, in February, you pick up a terroristic threat.
Yes, sir.
And now you've picked up another assault of a family member and a violation for protective orders. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 16th, 2025, in Harris County, Texas, officer was dispatched to an apartment for a family assault. Officer met with the complaining witness. The complaining witness had visible injuries on her face, including bruising on her eye and swelling on her head. Complaining witness went over to the defendant's house. Defendant grabbed the complaining witness by the arms and threw her into a table and chairs. Defendant began to punch the complaining witness multiple times in the stomach and slap her in the face. Complaining witness attempted to leave, but the defendant followed her through the apartment complex. The defendant currently has a protective order for terrorist threat, which bars contact between the complainant and the defendant.
Is that the violation of protective order?
Yeah, it's a felony, VPO.
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. Actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out the videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the responding deputies. If he had punched her in the abdomen, Your Honor, I can really say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, it appears, but she refused transport to the hospital. I couldn't tell from the body worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises, it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not go. He did not violate the protective order. And
The violation of protective order is a felony offense anyways, so.
yes, Judge.
it's not-
Yes, Judge. I understand. I understand.
So I just
And-
have, an assault, a terroristic threat, and now another
Right.
assault. So which assault is he alleging that's the,
Right, Judge.
right?
Yes, Judge. And she's filed or the state has filed a terroristic threat on her behalf, a charge on her behalf. If she was so terrified of him, Judge, why is she popping up at his
I don't know
apartment?
that that's actually true. Who's saying, he's just telling that to you? I mean, how do we know that's really true?
Well, she's there, Judge. Those are the apartments that are shown on the body worn cam video. It's his residence.
Is she actually on video at his apartment? Have you
They're
seen
outside
it?
of the apartment. They're outside on FM 1960. That is not her residence. The protective order has got a totally different address where he is prohibited from
Tell me, Sebastian.
going.
Okay, well, the VPO is not based on an address restriction, it's based on the assault of a protected person. And as far as the representations that defense has made today, we have no way of verifying any of that to be true. I disagree with the assertion that she shows no visible injuries. Her face does appear to be swollen with some red markings. Number three, the allegation that she's over at the house don't disqualify her as being a protected individual, and VPO is for an assault, not for a residency restriction. And at the end of the day, all those are fact issues. And what we're left with right now is the fact that in 2023, with a separate victim, he has an AFM, bond forfeits, then we have a terroristic threat with someone else, and now he picks up a separate AFM. And we can talk about how she's back all the time, but I think that ignores, first of all, the realities of domestic violence situations. And second of all, this isn't just one person that he's having multiple problems with. These are two separate people. So the state is going to stand on its motion to revoke and raise bail and is going to ask for $20,000 on all three cases.
Your Honor, may I respond? The complaining witness has not, has recanted to these March 16th, to the current charges, to the newer charges.
Which alleged victim is recanting, the first or the second?
The terroristic threat complaining witness, Your Honor. And the other assault family member case, Judge, the complaining witness is currently incarcerated. But
So which one's the
so,
The oldest one is in jail.
When?
and
Or
I'm not sure, actually. I had a colleague who spoke to her. I forget exactly which is in. She is in jail. As far as her recanting, I mean,
is she in jail for something against him?
no, I don't think so.
And also, Judge, the complaining witness, the one that the protective order is on behalf of, she has not given a rip on the terroristic threat case, Judge. So something's not right. She doesn't want to.
Problem is
Tell the truth.
he keeps picking up cases. Stuff keeps happening to him. It's just, I fall down and I pick up a new case.
Yes, Judge, and I did want
Are we
to-
supposed to just let him go because he's picked up now a felony? You
I
know,
just wanted to relate to you, Your Honor, that my client does not have funds. He paid he paid to get out with his income tax return, Your Honor. He paid to get out on these two new charges. He paid to get his car because he was not arrested at the scene, but he was arrested thereafter while he was driving. They impounded his car. He paid to get his car out. And he paid because to get a new phone or get his phone repaired because complaining witness broke his phone on the date of the alleged incident. And I'm asking the court to leave his bond as is, or in the alternative, Judge, maybe he can borrow some. He's got $250 left from the income tax return. And if you could leave it, or $5,000, he could possibly do that, but not 20. He was in jail for an entire week, Your Honor, when he was arrested for this offense, for these new offenses.
Pick up new cases. That's what happens. I have not asked you to do anything but be safe in my community. You're now working your fourth case. No, I don't want you to say anything. The only thing is that you continue to pick up new cases, and I can't just let you keep doing that without some kind of consequence. No, there has to be consequence to behavior, and the bill comes due. You can't continue to pick up new cases and expect good results. So I'm now going to revoke your bond. It goes with you. I can't. I have to show you that we mean business. Otherwise, we have no teeth. You know, what we say, it means nothing. I'm going to tell you now that I'm entering an order for protection in all these cases. And if you violate this, I can have a hearing to hold you at zero bond, and I will do it in a heartbeat to protect my city at all cost. If this person comes to you, you don't open the door. If they call you, you don't open the door. Or I'm sorry, you don't answer the phone. If they email you, you don't reply. But at some point, we have to say when. Now's that time. It goes with you.
Yes, Your Honor.
I'm not going to set it that high. I think that high is obtuse, and that's just, mean-spirited to go that high. But
Judge, this is 2 years worth of history here. Two different people.
that's why they set the felony bond at 30,000. But I mean,
You gave the first victim 10 stitches in the head.
10 stitches in the head.
I read that, Judge.
Tell me about the second one. What happened with the second one?
The second one is this one, and then you want
All
to
right,
tell
right. How
us.
bad are we talking injuries on the second?
Judge, it's swelling and then bruising in the head.
All right, so I'm going to do 10,002 on the first one, 5,000. So 10,003 on the first assault, 5,003 on the terroristic threat, and then I'll leave the second one as is. The new one as is.
Thank you, Judge.
So, no, then it has, no, I need a new one on. Do we need to file a new one? Okay, can you, Sebastian, file a new order for protection on the old case so we can have him sign it? On the
Yes, do you want it
2023?
on the two victims or just on the?
No, on both, on both, yeah. Mr. Johnson, you were charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
It judges, you know, the details of this case are.
Quiet.
Just.
Just read it.
Officer reviewed a police report from February 4th, 2025, after the officer spoke with the complainant. The complainant stated the defendant, her ex-boyfriend, called the complainant and stated that he was going to kill her and then showed up at her job. The defendant was approached by security and fled the scene prior to contacting the complainant. On February 24th, 2025, the defiant officer called the complainant. The complainant stated that on February 7th, 2025, she told the defendant via phone call to stop harassing her, and the defendant told her he did not give a fuck. On February 12th, 2025, the complainant received an email that stated, "Skip pussy bitch, I just love you." The defendant also sent a 20-second pornography video. The video showed a female laying on her stomach, nude, and the video zoomed in on the female's vagina with fingers being used to spread the female's buttocks to expose the inside of her vagina. The complainant recognized the hand and the fingers in the video to belong to the defendant and recognized the room. The complainant stated the defendant had previously emailed her on March 16th, 2024 from the same email, sending a picture of himself at work. On February 18th, 2025, the defendant emailed the complainant 6 times. On February 23rd, 2025, the defendant emailed the complainant 9 times. On February 24th, 2025, the defendant emailed the complainant once. The complainant changed her phone number on February 22nd, 2025, because she kept getting phone calls from unknown numbers, and when she would answer, the call would hang up. The officer texted a photo of the defendant from his Texas driver's license, and the complainant identified the defendant.
Pornography video that was sent.
We don't know the ID of the female in the video.
So, Your Honor, I think it would probably take some more investigating to figure out the identity of that female. So we can't speak about it. I don't know if it's recognized her. But that is.
She would say whether she recognized it was her. I would imagine that there's a whole host.
That's a felony.
Yeah,
If it's.
we haven't spoken to her directly yet, Your Honor.
It's just because it's been a flashback.
Mr. Johnson, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to order you not to have any contact with the complaining witness. I'm going to put a GPS monitor on you so I know where you are at all times. If I find that you go anywhere near this person, if I find that you try to have any communication with this person through any means, I don't care what it is, if it's Snapchat, if it's Facebook, social media, smoke signals, whatever it is, I will put you in jail. I'm going to do everything in my power to protect my community at all costs. I don't care who you are. Do you understand?
Yes, sir.
I'm now entering into what's called a Matchets Order for Emergency Protection. This is a court order that identifies Ms. Turner as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and will probably file a violation of protective order. It's one of the worst cases that you can pick up. Do you understand?
Yes, sir.
Okay, we need to talk about bond.
Your Honor, the defendant works for Enterprise. He's an IT specialist. He's been working there for over 5 years. And he's got ties here. He's been living in Houston for over 5 years. And he has child support for 3 children that he takes care of on the weekends. They're with the baby mom on the weekdays. But he does work, and he is working. And so we would ask that, and he's no threat. He's not shown any threat previously, and he does have strong ties. So we were requesting a bond of $1,500. We have the bondsman here today who could cover that.
I would be unopposed to a bond of $1,500 if he were to have a GPS monitor with an exclusion code.
I'm
So-
going to order it.
Yeah, so I'm unopposed to that as long as he has the exclusion code.
Bond will be set at the 1,500 then. You will get no more warnings, Mr. Johnson. You're in the free world now. Act accordingly. If I find that you do anything, it's not going to go well. Do you understand?
Sir.
Okay, all right. So you have a bonding company here now?
He's speaking.
Okay. He'll have to meet with Shaw first for all the bond conditions. Then after that, we can release him to the bonding company.
He's at the
Yeah, for sure. Okay. All right. Thanks, Joe. Good morning, Mr. Jenkins. So we brought you out because your lawyer wants to talk about what's going on with your case. I don't know. You tell me what you'd like to.
Well, Judge, there's several things I want to address, right?
Okay.
His reckless driving was dismissed. The felony case that caused you to place him in county and raise his bonds has been disposed of. It was reduced to a misdemeanor, I guess, last week or so sometime. So
I don't know. I don't know anything about what's
so now we're stuck with 2 terroristic threat cases, one against his brother, Watson,
Yes.
has spoken with his brother about that case. We were here, I believe, Tuesday. We reset it to today to see if the investigator could find any audio or video that was associated with one of the cases involving Crutch Fitness and an employee there. It's my understanding.
So I spoke to the officer. He told me he was going that day last week, and I've reached out to him again, and now he's saying he's going today.
Okay.
Yeah.
I mean, officers are busy. I
Yeah.
get, but, and we can't just expect them to drop on a dime to get something, right?
No, right, and I understand, but I think that if we were to come to a disposition of this case, like Mr. Jenkins wants, I think it's one simply just to get out of custody. And I think that
I get it, because no one wants to stay in jail, right? But
I also think that he has arguably some good arguments to make in his defense, not only for the Crutch Fitness case, but given now that his brother's not on board to prosecute. I was asking at his request for a time served. State is not willing to do that. They'd like him to be TRAS and whatnot. I'm partly out here asking so he can hear what's going on out here. Secondly, I see that the bonds are 10,000. His father is here present. His father came from overseas just to help address what was going on. They visited
that's
yesterday.
nice. Where's Dad?
Dad is right here at the front right
Come up,
here.
Dad. Come on. Thank you so much for coming.
So both cases are set at 10,004. With that present, I'm asking for a reduction in those cases. I don't think a personal bond, I'd ask for a PR bond. I have to ask. But given that a personal bond is not on the table with both those cases, I would ask for a reduction of 2,500 per case, Judge. And I say that because initially he was taken into custody. Jail therapy was part of the initial reason why, not the entire reason why. I think Mr. Jenkins has been in there since January 14th, over 2 months. I can see it on his eyes when we speak. He doesn't have the same livelihood he did whenever he was wanting to fight these cases. I think the jail therapy has worked. It's done its case. And I think 2,500 is enough to let him know that he has to be back in court, and whoever puts that money up, that he's responsible for that money in full, should he not
But
abide
it's
by.
not just to come back to court. Every time we give Mr. Jenkins a bond, he picks up a new case. Since January, we're on our 4th case. And they're dangerous cases. They're not cases where it's like a rinky-dink trespass or like a theft from a Walmart. No, they're serious, dangerous cases. Your first case is a reckless driving. While you're on bond, you pick up a felony. What was the felony initially that got?
It was a third degree evading of the motor vehicle.
So evade. So he's on bond for reckless driving. We ordered him, hey, no more reckless driving, please. Just think about the community. Don't endanger the community. Picks up an evading in a motor vehicle. 3rd degree felony, looking at 2 to 10 in the penitentiary. He gets out. Then he picks up in October a terroristic threat, gets out again, and then now picks up another terroristic threat the same month. So it's what we ask you to do. It goes in one ear and it goes out the other ear. And the problem is now you're stuck because the bonds are high. Your dad is here, which is great because it shows support. But the problem is, if I let you out, are you going to pick up a 5th case?
No, sir.
Well, I know you're going to say no. You said that the first 4 times. The only way I really get to know you is how you look on paper, because that tells me who you are. When you tell me something, for me now, it goes in one ear and it goes out the other, because I know you're going to tell me what I want to hear. It's little bunnies jumping in the woods, gumdrops and rainbows. But when you get out there, you turn into a different person. And it's not fair to everybody else who complies and the potential danger to everyone. We're not asking for much. I'm just asking to just be safe. Don't do anything. Think before you act. I've repeatedly told you that. So I get that you feel like, and you look but are we really supposed to keep doing this? State, what's your position?
Bond reduction, Your Honor. had a habeas issue, pending cases. Direct driving is not dismissed by us, it's dismissed by felony. Part of his plea negotiations with felony there. They would be opposed.
How is it that just the two cases were, I mean, because they're not even in the same,
Right, I don't.
same transaction. I don't understand how these things are happening now because I see a lot of judges complaining of, you know.
Because I did not file that, and I was like, I'm pretty sure, so I went to check and it was a felony prosecutor.
So who is the first terroristic threat?
The first terroristic threat was brother.
Who's the second one?
Second one is a manager at a gym.
Here's what I would like to do. I would like to have him TRAS to see how we go forward, because I just don't know. A TRAS is an evaluation where we have clinicians talk to him and see, they ask him all kinds of questions about his life, about his history, any drug history, you know, living situation they ask, and they determine that, you know, okay, this person may need treatment. This person may not need as intensive in treatment to where he can be on the outside and doing it. I don't know how to go forward, but it scares me because I don't want him to pick up a fifth case. I don't know what he's doing in life. You know, did you graduate from high school?
Yes, sir.
How do I know that? You know, I mean, just you're headed nowhere quick. And we don't want to see that. We don't want you to end up as a statistic. I mean, sure.
I've been trying very, very hard to get a startup in sales because I want to do sales. That's the best way for me to go without having a degree because I didn't want to go to college. I wanted to be an entrepreneur. And so doing independent contractor work, it allows me to be able to make money, you know, on my own time and then invest into what I want to invest into on the side because I don't believe that working a job for the rest of my life is a way for me to live my life. And I agree with you that I keep on catching cases, but it's not because I want to start trouble. It's just because I have too much time on my hands and the things that I want to get started, I haven't gotten started yet because I procrastinate a lot. I know that I do that, but it's not because I can't control myself. I have a lot of self-control and if you let me be free, it's
Terroristic
not.
threat says the otherwise. A terroristic threat says that when you get angry, you pop off and you have no self-control and you start throwing out threats, right? Without, that says no self-control.
Well, I would say, Judge, on that one, just this is at a gym, but there was also a basketball game that had just happened. So it's important. And the reason why I brought up the evidence, because, you know, there's two sides of the story. And so I just needed to verify.
I always, right.
Right.
There's
We
always
understand that.
two
I just want him
sides.
to know that, you know, we're advocating for him as well, that we are doing the investigation. And I worry that if he just signs to get out, that it puts him in a cyclical sort of situation, one, and two, that he's only doing it just because he doesn't want to get out. And that's why I'm addressing the bonds.
I'm not going to take it.
And that's why I was addressing the bonds, because and this is not even a guarantee that father is going to pay the bonds. This is just to.
Let me ask you this. If we let you out, where are you going to go? Where do you have to go?
My mom, she'll let me stay back at the house. I know that if she doesn't let me stay at the house, then I'll find a place to stay. But
I'm not letting you out to the street. They'll eat you alive.
well, I was
The only way that I would even.
I have family on the outside.
But if they're not going to take you.
That's not
It's a
fair
problem.
to have me in jail because I had a place to stay and now I don't because I was in jail. Being in jail is not the place for me. The only way to elevate my life.
4 different chances, Mr. Jenkins.
I wasn't in jail before those chances. I've been in jail now, so I understand my consequences more. That's what jail is for, to learn your lesson.
You live across the country or
We have been living in Europe for the last 6 months. So I took an assignment in Europe.
Who else? Is there anyone here that's willing to take Mr. Jenkins in?
Well, he's crossing the bridge with everyone in the family.
He's burned it. God dog it. You know, it's never good to burn a bridge because you never know when you need to cross it. When you act like an a-hole to everybody and you shut everybody out, this is the exact example of why you don't do that. I would consider if you had a place to go, Because I'm telling you now, I'm not letting you out to the street. If you have nowhere to go, then that's set you
Find a place
up.
to go, but I can't find a place to go if I'm in jail. I have nobody to call in jail. Nobody answers my phone when I'm in jail. So if I stay in jail, that's gonna be my life forever. It's gonna be a kid that had a chance in life to a kid that has a life in jail now because of a few mistakes that I know not to make anymore.
Let this be a lesson.
If I'm able to go through the MAC judge and find some kind of social program, and work that way and provide evidence to the court that they can house him. My parents will help me find a homeless shelter. They'll help me find a homeless shelter to stay at. Like they did that before. I just don't want to preempt.
Really?
He burned every bridge. He has I have 6 boys and he's number 5. His auntie, his grandmother, and he shoot everybody's fan. So
I've stayed in the homeless shelter before and I've done well in the homeless shelter. I was able to take care of myself and function into homeless shelter and they helped me find the homeless shelter. So I can find a place to live, but if I'm in jail, my life gets worse and
I know you're desperate to get out, but I don't understand what could have been so bad that you burned so many bridges with damn near everybody in your family. What the hell happened, man?
I started.
You know?
Just reflect on that. Don't answer.
I mean,
evaluation would be great. 'Cause he was evaluated before and he was medicated, but he refused to take his medication.
that's big. You know, the problem is, Mr. Jenkins, is that we get a lot of people here that they're supposed to take medication, right? And they start to take it and things go great. The problem is that things do go great when you take your medication. And a lot of people say, you know what? I don't need this anymore. I'm doing great. And when they stop taking it, everything turns right back into scheisse. You know, that's the problem. When you're taking your medication, things go great. You must continue to take it.
Can I say something? Hold on. The medication.
Not talking about the cases.
I know I'm talking about the medications. The medications, they were making me drowsy. So I was in process of getting on new medications that were uppers and not downers because at the time I didn't have a car. So I was going through a lot more shit. So it was the same position I'm going to be in now. So I know that's not a good argument. But finding a medication that has me up instead of down so that I can function and find a job and make money. Because really, it's not, but my life is bad and I'm going through what I'm going through because I'm not where I want to be in life. I don't have any money and I can't take care of myself because of that. So that causes a lot of mental illness. That's what you can call it, mental illness, but it's really just going through life and having stress going through life. That's the problem I'm dealing with, not having any money. So once I have money, you'll see a completely change. It'll be like I'm on the best medication ever once I have money.
Do you think that me just letting you out, poof, you're going to get money?
I'm not saying that, but I can show you by going to the therapies and the classes that I'm doing better, and then I'm trying to elevate my life to a point where I can take care of myself, and I don't have to depend on anybody in my family. And then you'll see that poof change once I'm in a position where I can take care of myself. I can promise you that you'll see that poof change as soon as I can take care of myself because I have money now.
Schedule the assessment for Monday.
Great. I'd like to do a TRAS to see how we go forward because I don't know. But I'm going to tell you now, I'm not letting you just out to the street. So do you mind?
I will research through the program.
No. But also perhaps if you can try to make a good faith effort to reach out to the family, see if anyone, I'm happy to talk to them too, to try to help convince to see if they'll.
We speak extensively, but yes, sir.
So we're talking to have him sent to Job Corps. So there's a Job Corps at St. Marcus that he qualifies for because he doesn't have any felony. So he can go to Job Corps, learn a trade, and stay up there if he's willing to do that.
The problem is he going to do it?
Right.
Yes, sir. I will do it though. I'm very.
If you're in jail, everybody will say anything just to get out of jail. And then when you get out there, though, what's really going to happen?
I don't have a car, so I need to find a way to support myself. So any job right now is a good opportunity for me because I have to save up to get a car to take care of myself.
Mr. Jenkins, where is Job Corps? Is it just in San Marcos? There's nothing
Got
here?
some other ones, but that's the closest one.
Because what I'm thinking is that we could probably do something to try to resolve these cases and perhaps make that a condition that he does Job Corps.
Is it possible that the court could order that as a, well, I'll discuss it whenever we.
Right. I would say that we do it as part of perhaps some kind of global agreement where, first have him TRAS, let's see what they say. And then perhaps we make it a condition that he does Job Corps.
Yeah, that's,
And the thing, I don't know if it's in San Marcos, I have an issue because I don't know how we can supervise it, right? But if there's something here, that would be great.
I'll just lay
Or
it on.
something closer.
Are we? Preferred, or is that 12 months so we get T-Rex?
You try
Last
that.
week, not a cluster.
First have them TRASed,
Sure.
see what they say. Come back on Monday or probably Tuesday or Wednesday. This is because we got to give it a couple days.
You need a drug test too? A drug test?
He'll be clean now. He's been in custody. Well, I hope they don't have dope in the jail. I mean, I know that he's been in custody for quite a while, but if we do let him out on, say, some kind of diversionary program or probation or whatnot, he will absolutely be tested, and a lot, because I would make it a condition that he gets tested a lot. And I'm going to tell you now, if you do get out, one of the conditions will be that you take your medication. One of the other conditions is that you get your driver's license. One of the other conditions that, we'll try to find you some kind of housing so that you have somewhere to stay, because I don't want you out on the street, and that you get to the job. So we want you to succeed. I don't want you to just stay in jail. I don't want you to be a statistic. I want you to leave here better than you came. But me just letting you out now, just for shits and giggles, that it would throw you out to the wolves, because I think that you, with proper structure, you're going to go do what you've been doing for the last.
I need to be transferred because in my pod, they were touching on me inappropriately and saying sexual things that were making me uncomfortable.
And Judge, not regarding that, that's another issue. The reason I was hesitant to sign a defer is because I was expecting to see, I got to make sure that the evidence is correct. Well, and I really wanted to see.
You don't have everything?
No, I'm saying the surveillance that we were waiting on from the investigator. I was
Oh,
wanting.
this is from what you were talking
Yes.
about. Okay, I get it.
I'm keeping that off of it. This is not tracking.
No. And I'm saying from
So,
part,
look,
and I think
just,
I didn't want to, Judge, just have him sign something just so he can get out. I understand he's in jail and I understand it's bad in there.
let's have him TRAS.
Sure.
In the meantime, try to get the video, subpoena the officer to get here, because it's been since October.
She's been looking for him. I'm not saying they haven't done anything.
Yeah.
But I'm saying as my job as well, I got to make sure that, the
Sure.
burden is held and.
But if you subpoena the officer to come to court, that,
Fully
you know what I mean?
and that, Your Honor, and that's why I'm keeping the offer open. It's not trying to put the pencil in the spot.
No.
It's
That's-
just.
I didn't
keeping
feel that
the
as
offer
well.
open. It's not like I'm trying to rush through
So-
it here.
Have him evaluated Monday. It takes 2 to 3 days to get the results. In the interim, Matt's going to get all the evidence so they can see the surveillance, they can see everything, so that all you guys can have a meeting and see what is out there. And then perhaps maybe like Wednesday or Thursday, we can come up with a plan on how to go forward. Is that okay? Matt,
Yes, sir.
how long
So-
do you intend to be here?
I'm gonna be here until we resolve it. I was supposed to leave on the 29th. I can stick around.
Okay. We'll try to do it as fast as possible.
I have to be back by the 11th.
Oh, yeah. Well, sure, absolutely. My main concern is where is he going to live when he gets out? Because
His plan was his vehicle, but his vehicle is repo. Which is found out yesterday because we didn't know where it was at. So it's the car that he was.
car's gone. Car's gone.
I understand. So I have 3 vehicles I was gonna try to get him. I don't know if he has a license or anything.
Can you run his license, please? Before you just start driving and getting out there, just make sure that you yourself are good. Before you start doing all
I'm
this.
very cautious.
Just listen real quick and then you can speak.
I know you are, but I mean, taking the medication, if you're taking any, so that you get everything, you do it in steps. You don't start running or start walking. There's a process.
I need to be out of jail. My mental is way worse when I'm in jail than when I'm in the free world. In the free world, I'm on way better position to take care of myself and elevate my life to where I need to be. In jail, it's the opposite.
Okay. This is what you consider when you're out there in the free world.
And I understand. I wasn't considering that before, but I will now that I've been in jail. I understand what jail is, and there's a place I don't want to be. I understand what I'm dealing with on the free world and what I need to do in the free world in order to not come back to jail. I understand
Mr.
that.
Jenkins, we're in the home stretch.
You gotta stop replying.
We are in the home stretch. Matt, in the interim, if you could please just find,
Yes,
you
I
need
will
to
do.
find a home. I'm happy to talk to any family members to help try to convince.
The shelter that he was in before, the shelter he was in before was an age group, and they have to have beds. So he wasn't in a real homeless shelter. He was in a place where children go from 18 to like 21. That's a shelter, but I think all that's over now. So he won't be able to get him in one of those places. The only other place he can go to a real shelter that he has to be in at 6 o'clock to get up in there and live on the street or go to Job Corps. So he doesn't understand that those shelters doesn't exist anymore. Those kids shelters.
Where's that?
I understand that, sir.
And
I
that's
can-
it. And he's aging out, so he hasn't taken his medicine because he's 22 now, so we can't make him take his medicine. We can make him believe.
I can as a condition of anything to release. So we will make it. And if it doesn't start happening, and if he doesn't take the medication, he'll stay with me. And we'll keep doing this until it takes. I can hold on to you for 3 years, man. Really. All right. I think we're good. We got a plan.
Yes, sir.
We'll set it for, I guess, Tuesday or Wednesday, and we'll come back and then hopefully we can have everything resolved. Okay? Thank you so much for coming. Really appreciate it. You are Adan Ruiz.
Sir.
Mr. Ruiz, you're charged with 2 cases. You're charged with burglary of a motor vehicle and tampering with a government document. On the burglary case, you're facing up to a year in jail. Likewise with the tampering, up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 20th, 2025, an officer was dispatched to a burglary of a motor vehicle that occurred in the Old Navy parking lot in Harris County, Texas. The officer spoke with 2 witnesses who viewed the incident. Witness 1 stated the suspect motor vehicle pulled up to the complainant's motor vehicle, and the suspect was wearing a camo hoodie and had gotten out and pulled the door handle of the complainant's motor vehicle, attempting to open it, setting off the alarm at the same time. Witness 1 advised the suspect got back into the car and drove to another area of the parking lot, parked, and waited for the alarm to stop alerting. Witness 1 stated once the alarm stopped making noise, the suspect drove back over to the complainant's motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complainant's motor vehicle. The complainant advised that she was walking up to her vehicle when she saw a Hispanic male wearing a camo jacket hoodie sitting in the driver's seat of her vehicle. The complainant stated the suspect saw her walking up, jumped out of her vehicle, got into the passenger side of a vehicle waiting with an unreadable paper plate. And the complainant advised she heard a male tell the driver to go, go, go. Another officer advised he was patrolling when a gold Tahoe, which was the description in the vehicle before, driving at a high rate of speed past him. A traffic stop was initiated of that vehicle. The officer was able to send pictures from the witness showing the suspect vehicle leaving the location to other officers who were able to verify the suspect vehicle. After further investigation and search of the vehicle, a camo jacket was found in the rear seat and a flat pointed screwdriver consistent with the tool that would be used to break the lock on the complainant's vehicle door. Defendant 1, Ruiz, is a registered owner of the Tahoe, but the motor vehicle was displaying a counterfeit paper tag that did not come back registered to any person or any vehicle. Defendant 1 was identified by his VIN number and booking photos. Defendant 2, Cerna, was identified with his VIN and booking photos.
Who was the one who actually went allegedly into the car? Was that Cerna or was that Ruiz? And is Cerna here?
No,
Oh, yeah, he has 2 felony warrants. On Cerna, bond gets revoked at 10,002.
I am not able to tell, which of the suspects was the one allegedly wearing the camo hoodie and the one that physically entered the vehicle from the dim sunlight.
Mr. Ruiz, since 2020, felony evading, theft, felony retaliation, assault of a family member, felony unlawful carrying of a weapon, felony theft, and now tampering and a burglary of a motor vehicle. I want you to understand that I'm going to do everything in my power to protect my community at all costs. I don't care who you are. I don't care what color you are. If you're a small farm animal, I will do everything in my power to protect my community at all costs. You are not to hang around with defendants. I'm going to put a GPS monitor on you and I'm giving you a curfew. I don't want you out in the middle of the night. You're not to use alcohol, illegal drugs, and I'm telling you now, I'm going to test you like crazy. If I find that you're using, it's not going to go well for you. So understand.
Sir,
What do you do in life now? You work?
sir,
Did you graduate from high school?
sir.
You did?
No, sir. I got my diploma, my GED.
What are you doing now? Are you working?
Yes, sir.
Good. I want to know that you're actually working and that you're going to be a productive citizen. When people have too much time on their hands, they become self-destructive. And you now are headed for a 25-year sentence or an actual death sentence because people in Houston, they like their guns and they like their cars. And if you muck with the wrong person, they're going to shoot your ass dead. It happens at least once every other month here. We have someone who's dead because of a gunshot because they break into the wrong law. You understand?
Sir.
You are not to go within 500 feet of where this person lives, works. Is it an apartment complex? What is it?
This was at an Old Navy parking lot, Your Honor.
I don't want you going anywhere near there. Is it a park? Is it like a mall? Guys, 9 p.m. to 6 a.m. No drugs, no alcohol, no weapons, no contact with the co-defendant. GPS monitor today with a 500-foot exclusion from where this offense occurred. I will give you a lawyer today.
Sir.
I'm going to do everything in my power to help you straighten up and fly right. And if you force my hand, I only have one place for you. Do you understand?
Sir.
Hang with dogs. You get fleas.
It's a strip mall, Your Honor.
Okay. Whatever that strip mall is, he's not to go there. And then, so Blaze, if you don't mind sending that to them, please.
Absolutely.
All right, Mr. Reeves, I'm going to have you sign a reset with Victoria. I'll have you meet with Creechall, and then I'm going to have you take a seat in the jury box while we get you a lawyer.
Sir.
Good morning.
Hey,
I'm here today on Joe Greathouse. He's got a pending BVR for a high brass.
Mr. Greathouse, come up. This is the one that you said that he's a truck driver. I had initially taken away his privilege to drive, and then we gave it back, right? And now testing positive for alcohol.
It was a high brass. Judge, I'm gonna just tend to this thing. I have. Should we approach?
Sure.
This is, I had my client, we were notified about the BRAC. I had to go to Quest Diagnostics and take an alcohol test. It shows negative. Now, it is a couple days later,
I mean, really?
but if somebody's drinking, Judge,
Really?
drinking enough that they're gonna violate on a machine, why would they stop? If you've got such an alcohol problem that you can't stay straight on the machine, why would you stop?
That's, no, I don't believe that for a second. That doesn't fly. The only thing I know is that
Judge,
he didn't do a retest like he's supposed to right afterwards.
can I talk? So what he's telling me is that he was getting in the car to start a shift, that he has to start real early, right? He used mouthwash, right? That's what you're telling me. Hold on.
Really?
Hold on.
And now it's mouthwash?
Well,
What's next? Abducted by aliens?
Your Honor, I don't think I'm being inconsistent. He tested negative for alcohol. You tell me.
3 days later.
I judge, admittedly, I told you that. Admittedly, it was 3 days later. But what I intended to the court is, if somebody's got, a bad enough alcohol problem that they can't stay straight on a machine, why would they stop drinking? People that are chemically dependent, they may not be able to stop, right? What I've told my client, Judge, is that you can't use any alcohol products at all, right? And you understand that, correct? And so you've got some mouthwash now that is the hydrogen peroxide type, correct?
It's a great house. I'm now again taking away your privilege to drive. And I'm now going to put a scram on your ankle so I know that you're not consuming alcohol at any time. And if I find that you do, I'm well within my right to put you in jail right now, Mr. Greathouse. So be lucky that you're not going to jail right now. But if I find that you test positive, and I don't care if the Queen of England comes down and says, let's have tea and crumpets, you test positive for alcohol again. Do you understand me?
Your Honor,
What are you
the
gonna say?
defendant's
Can I work?
license is
He's telling me
coming
you
back
can't
as
drive.
ineligible already.
I'm sorry.
Your
The defendant's
license is, it's ineligible as it is.
I'm gonna have to look at that. I'm not in receipt of
They
it.
have access to the Texas Department of Public Safety's driver's license to see whether a license is valid or invalid. They've looked it up and they're saying that your license is not valid at this time. You're not allowed to drive regardless. It's suspended at this time. I mean, I know that you're looking at me like this, but the system is saying it. So don't drive. So what I'm going to do is I'll have you come up here, swear to us that you're not going to drive. After that, you'll get with pretrial for your bond conditions. They're now going to put a monitor on you. This detects alcohol through the perspiration of your skin 24 hours a day. Don't use. You need to be cognizant of everything that you put in your body. You know how many, if I had one strand of hair for every time someone told me that they use mouthwash, my hair would look like Mr. Johnson's hair. Really. That's why we advise every single person, as soon as they're given bond conditions, do not use this, do not use that, do not use this. Regardless as it is, your license is now suspended, so you can't drive regardless. So you guys need to figure whatever that is out, and then we'll talk. All right.
Thank you, Judge.
Thanks. You're Ronald Umanzor.
Yes,
You speak English?
yes.
So you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 20th, 2025, an officer observed the defendant's vehicle in the street and observed the defendant talking to prostitutes on the street in or around the 3700 block of Tidwell Road. The officer followed the defendant's vehicle into a nearby motel and they were almost struck head on by the defendant. A traffic stop was initiated. The officer observed the defendant to be the driver and sole occupant of the vehicle and observed the strong odor of alcohol upon his breath. The defendant refused to answer questions without a lawyer present. The officer observed the strong odor of alcohol upon his breath, slurred speech, and bright glassy eyes. SFSTs were conducted 6 out of 6 on the HDN, and the defendant refused the walk and turn in one leg stand. The defendant refused to provide a breath specimen.
Judge, that's not how I read the offense report. I read that after he almost struck them, they then followed him, and then he came to a complete stop in the roadway, and then they stopped him. So I don't see any traffic violation,
I'm looking at the dim side, Judge.
Okay.
And that's for me, it's a distinction from what was read. So what?
It says, they viewed the defendant, speaking to prostitutes on the street and around the 700th block of Tidwell Road.
Talking to people.
Officer stated, sorry, Judge.
I-
Yeah, thank you. I'm just reading. Yeah. Officers stated that they followed the defendant's vehicle into a nearby motel and they were almost struck head on by the defendant's vehicle as it exited the motel parking area. The officer then stated that they have activated their emergency lights in the patrol vehicle and got behind the defendant's vehicle.
Did they let him drive a little bit and then pull him over, or was it?
Yeah, he got into my understanding, he got into the roadway and then he came to a stop and then they stopped him. So I don't see any traffic violation. I don't see any crime being committed.
I mean, I don't know. I mean, perhaps there were. She's saying that he almost hit them, right? And maybe he went out a little bit more and then sees them, and I don't know.
No, yeah, they're asking you to
Saying that
assume.
hits them, so at that point they pull him over. I mean, go get the video, go
Sure.
get body cam.
Sure.
You see something different,
Sure.
always. I do think that there's sufficient probable cause to go forward with the case. Mr. Umanzor, can you run his license, please?
Yes. His driver's license is eligible, Your Honor.
I am now placing a restriction on your license, Mr. Umanzor. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir. No, sir, Mr.
Yes,
Almanzor.
sir.
Likewise, you are not to drive any vehicle unless it has an ignition interlock. I'm sending notice to DPS in Austin so that every single officer in this state knows if you're driving a vehicle that doesn't have a blow and go in it, they're going to arrest you and put you in jail. Do you understand?
Yes, sir.
I'm not asking much. All I want my streets to be safe, and I'm going to do everything in my power to protect it. You got a great lawyer here. Listen to Herman. He'll take care of you. Because you have a lawyer, I will waive your appearance, but you must stay in touch with him. If he tells me he can't get a hold of you because you're playing games and you've gone AWOL, I will issue a warrant for your arrest. For now, I'll have you go to Victoria, sign a reset. We'll have you get with pre-trial for your bond conditions, and after that, you're free to
I
go.
think you already had the interlock and everything previously. And it's the agency. Okay,
All
great.
right.
Mr. Almanzor?
So I'm here on Mr. Hunter. He had an issue, he bond forfeited, he's back for an arraignment today. I've spoken with the state, they've made an offer. We're asking for one setting for Mr. Hunter to consider that offer. And then the state is going to eval the case if not, and if reasonable minds still disagree.
Where is Miss? I don't even see Mr. Hunter.
He's in here. Mr. Hunter?
Has he made,
Yes, he bonded out.
sending him for a drug test right now.
Okay.
Right.
I don't know what you have offered.
They're part of here.
I like it.
And just,
I'm going to tell you now that it's not going to be this revolving door anymore.
right.
No more revolving doors for you, Mr. Hunter. You understand? If I find that you're using, it will not go well for you. You come to court whenever you want to come to court. Well, that's not the way it works. I'm sending you now for a drug test. I guess we'll come back Monday and address the results because it's now 11 o'clock. I don't know.
Okay.
I just don't know if it's enough time.
Okay. And Mr. Hunter just informed me, he drug tested yesterday. So I don't know if we have those results yet.
The pre-trial people,
But yeah,
the pre-trial people that I'm auditing the drug test, maybe Monday and
I
Thursday.
don't know how because there was no order from us. If he's on the land and then he makes bond, those bond conditions are valid. You know what I mean? So we can't just. Shh.
Okay, so when he was released, there were bond conditions in place that he needs to report on Monday and Thursday for drug testing.
Okay.
And so he did that yesterday.
Did you test?
Yes, it is, Judge. It is, from the drug test that I see, yesterday. It is consumption deposit for. Okay, I'll let this. All right. So yeah, production deposit for THC, Endo, Oxy, and.
You will now test every Monday and Thursday. You test positive for anything else, it's not going to go well for you. You understand, Mr. Hunter? Now is the time for you, once again, to address any issues you may have. If you don't, I'm going to address it for you. Okay? So we'll let him go now.
Okay,
Continue with the same bond conditions that we've always had,
okay.
and then he'll test again on Monday.
And so we're, just to let you know where this case is heading, the state has asked for one setting to eval it. And then, if reasonable minds still disagree, then we're gonna, set it for a dispositive motion to suppress with the court's permission.
I don't know. I mean, I'm just going to set up a trial.
Okay, we can do that too.
It's just way too much drama, man. I'm not going to, just
Well, we'll have to see.
let a jury decide.
So you'll go do the,
So,
we'll stand down, Judge.
yeah, just, okay. Anna will continue like always. He's going to be back Monday and test.
Let's go.
Thanks.
Manuel Cooch, who is in custody.
Okay. I'm bringing you out now because I have great concern with your cases and the way that your bonds were set at this time. It appears that in September of last year, you pick up a felony assault of a public servant and an evading arrest. A couple months later, an aggravated sexual assault. And I'm assuming he's out on bond for all this stuff, and now he's picked up another case. You now stand charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 17th, 2025, at approximately 2:46 p.m., officers were dispatched to 3099 NASA Parkway, Houston, Harris County, Texas, for an intoxicated male who had fallen off his bicycle and dropped his firearm onto the ground. Upon arrival, the officer observed other officers detaining the defendant and transferred custody to the affiant. The officer spoke to the witnesses, who stated they observed the defendant in an intoxicated state, walking along the sidewalk and stumble onto the ground, and they observed a semi-automatic firearm fall out of the front pocket of the defendant's hoodie. Witness 1 retrieved the firearm from the defendant and handed it to witness 2. Witnesses then had held the defendant until police arrived. The officer attempted to question the defendant, but the defendant was unable to provide the officer with information as to why he was in possession of the firearm due to his intoxicated state. And the defendant was identified via his U.S. residency card.
Does he have an ISO? Do you know? Mr. Cruz, I'm going to find that there's sufficient probable cause to go forward with your case.
He does have an ISO, Judge.
Did you have anything you want to?
Your Honor, I'd also like to add that a condition of his felony bond was to not possess a firearm. So this needs a BPO.
I think Mr. Cruz, they've given you chance after chance for you to remain out on bond. And I find by clear and convincing evidence that you refuse to comply with bond conditions. There are no non-financial conditions that we can do that will enable you to comply. As a result, I'm now going to revoke your bonds and I'm going to set them all at 10,004. Because of the actions now, I think that
You guys have a high
you now have an immigration detainer. So, have you know anything that's gonna happen with that by chance? Have you know? Okay. So I don't know if you're going to get out. If you get out, I'm ordering you to be under home confinement. You are not allowed to be released unless you have a GPS monitor on your ankle. And then I'm also on your other ankle, I will put a scram monitor so I know that you're not consuming anything. You are not to consume alcohol, illegal drugs, unprescribed controlled medication. You're not to be in possession of any weapons. Do you understand, sir?
Yes.
Okay. We need him to sign the conditions and then after that, we'll set him. It looks like the felony is set for, May. Let's do 30 just in case. And then if nothing's happened in the felony, then we can do another 30 after that time. So, okay. Thanks. Good morning, Miss Alexander. Ma'am, you're charged with the offense of driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You are Janae Alexander?
Janaya.
Janaya? So you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
On March 22nd, 2025, an officer responded to a minor traffic incident. Upon arrival, the officer met with the wheel witness officer who stated that he was conducting a safety control of a disabled 18-wheeler on the shoulder with his emergency lights activated. The officer stated that he was on the shoulder when he was struck on the driver's side by the defendant's vehicle. After the crash, the officer observed the vehicle to continue to travel southbound. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and immediately detected the strong odor of alcohol upon her breath and slurred speech. The defendant exited the vehicle, and the officer observed unsteady balance. The defendant admitted to consuming alcoholic beverages prior to driving. The affiant officer made contact with the defendant and observed the same signs of intoxication. The defendant stated that she was on her way home from a bar and consumed 1 minute's drink at 9 p.m. The defendant stated she was unaware of when she struck the patrol vehicle. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues observed on the walk-in turn. 2 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.202 and 0.201.
Any prior DWI? And
No prior judge.
license?
Oh, yeah.
Okay. Ms. Alexander, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Ma'am, look at me. If I find that you're using, it's not going to go well for you. I'm not asking much from you. If you do not have a valid Texas license and liability insurance in your name, car insurance, you're not allowed to drive. That is also a condition. Do you understand? How old are you, man? You're,
23.
do you have the ability to hire a lawyer? Would you like to apply for a court of appeal?
I don't have, I need one.
Okay. So Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box while you fill it out. You will meet with pre-trial bond conditions, then I'll have you talk to someone here shortly. Okay? Yes. Are you Victor Ortiz?
No, Judge.
No, this is Osman Rodriguez.
Yes.
Mr. Rodriguez, you're charged with driving while intoxicated. You're facing up to a year in jail and or $4,000. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 21st, 2025, an officer responded to a two-vehicle accident that occurred near the 5,000 block of Bingle Road. The complainant stated that she had made a right-hand turn northbound on Bingle Road and was already traveling northbound when she was struck on her driver's side by a white van. The complainant identified the defendant
as the sole occupant and driver of the striking vehicle. The officer made contact with the defendant and observed red, glossy eyes, the strong odor of alcohol upon his breath, and smoke. The defendant stated he consumed 2 beers, one at work and one in his vehicle as he was driving home. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 4 clues on the one leg stand. 3 out of 8 clues on the walk and turn. The defendant consented to provide a breath specimen. The results were 0.160 and 0.177.
Did they find alcohol in the car? Substantiate that allegation.
Doesn't state in the VIN, Judge.
Does he have a license? And any prior to DBIs?
He does not have a driver's license and no prior DWIs.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with the case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. That is a condition of your bond. I will have you sign with me today a promise to me that you're going to make. This is an affidavit that I take absolutely serious. I don't care what's going on in your life. I don't care if you have a bunny that needs operating. If I find that you drive, it's not going to go well for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and you will be randomly tested. If I find that you're consuming, likewise, I will revoke your bond, put you in jail. No more PR bonds for you. You have a lawyer. Because you have a lawyer, I will waive your appearance. Mr. Rodriguez, it is your responsibility to stay in touch with him. If Mr. Salinas tells me that he can't get a hold of you because you're playing games, you pick up a new case, you endanger my community, I will put you in jail. For now, I'm going to have you come up here and swear to us that you're not going to drive. I will get you to Victoria. We will have you sign a reset. And then after that, I will get you with pretrial. And then after that, you're free to go. Come on.
Yes.
Mr. Sierra, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer observed a vehicle engaging in a legal street race at the 12,425th block of Wood Forest Boulevard in Harris County, Texas. Both the defendant's vehicle and another vehicle passed the officer at a high rate of speed while attempting to pass each other in a competitive manner in an attempt to outdistance each other. The officer observed the defendant drive 96 miles per hour in a 40-mile-per-hour zone. A traffic stop was initiated. The defendants began to pick up speed while swerving through multiple lanes and cutting off other drivers on the roadway in an attempt to outdistance each other. The defendant admitted to speeding but denied racing. The co-defendant is a juvenile.
You want his license? Let's see if he has a license.
Yes, Judge. He does not have a driver's license on file, Your Honor.
Mr. Sierra, I'm going to find that there's sufficient probable cause to go forward with your case. You do not have a Texas driver license. You are not allowed to drive. I'm going to have you sign with me today an affidavit, a promise that you're going to make to me that you're not going to drive. I don't care what's going on in your life. If I find that you drive, I will put you in jail. And if you're not in this country with permission and you go to jail, it's very possible immigration puts a detainer on you and you will be in there until this case is over with. How old are you, sir?
20.
Did you want to apply for a court-appointed lawyer?
Yes.
Look at me. Heed this warning. You get no more. If I find that you're a danger to my public in any way, I will put you in jail in a moment's notice. Do you understand? Think before you act. You hang with the wrong people, it's not going to go well for you. Come on. All right, Mr. Wong, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 18th, 2025, an officer was dispatched to a call for service in reference to a major crash. The witness stated that he observed the defendant sitting in the front driver's seat behind them and crash into another vehicle by rear-ending it at the 9,000th block of Bel Air Boulevard. The witness stated that he observed the defendant was driving recklessly prior to the vehicle crash. The officer observed a strong odor of alcohol emitting from the defendant's breath, slurred speech, glossy eyes, and slightly unsteady balance. The defendant admitted to consuming an unknown amount of alcohol. SFSTs were conducted. 6 out of 6 clues were served on the HGN, and the defendant was unable to perform the walk and turn test in one leg stand due to a past ankle injury. The defendant consented to provide a breath specimen. The results were 0.123 and 0.122.
How many prior DWIs have you in an NCIC?
Yes, he has 1 prior DWI.
Here, anywhere else, anything else? No? Great, license?
He does have,
Please.
he does have anything, John Wall.
Right. That's who it needs to be, not Dan.
His driver's license is eligible, Your Honor.
All right, Mr. Wong, I'm going to find that there's sufficient probable cause to go forward with the case, and I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. No more PR bonds. I am now also placing another restriction on you because it's a second offense. I'm ordering you to obtain an ignition interlock, and you're not allowed to drive any vehicle that doesn't have one. If you're caught driving a vehicle that doesn't have one, you will go to jail. Do you understand? I'm sending notice to DTS in Austin so that every single officer in the state knows. You understand? Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with the other Mr. Wong and he'll tell you if and when you have to come back to court. For now, I'll have you go to Victoria, sign a reset. You'll get with pre-trial for your bond conditions and then you're free to go. Oh.
Just June 3rd through the 5th.
Mr. Wong, did you hear that?
Yes, I did. Your Honor, I just have one question. The vehicle that he is driving to and from
Oh,
work.
is that what
he
you were
also-
about to say? Come on up. So,
It,
what we will
the
do-
ignition. I'm sorry, Judge. Go ahead.
is it inoperable, I guess?
It's inoperable at this time. We don't even know if it's going to be repairable. But the point I'm trying to make is that the vehicle that he drives, he shares with his mother. So I don't know if that with the ignition, the system, if that's going to be something that.
You're not allowed to drive any vehicle that doesn't have an interlock on it. So if you're going to drive
Okay.
mom's vehicle, it has to have an interlock on it, and that's it.
Okay. That's just okay.
No, I don't want you driving any vehicle that doesn't have an interlock. I mean, I want to make
Okay,
sure that if you get in a car, there's no alcohol on board. That's it. So
Okay.
if you want to get a portable device and you're telling me you're not going to drive, I'm going to have you sign an affidavit promising me you're not going to drive. So, whatever vehicle you put it in, or if you're going to drive, okay, you got to have one. You make the decision. If
Judge.
you want me to give you a portable device, I'm happy to do that, but you're going to promise me you're not going to drive it.
Okay.
So I guess, just let them know what you want to do. I mean, if you want to take time to think about it, I'm happy to give you time as well.
Yes, Judge. That would be great. Let me confer with my client, and then we'll
Yeah,
decide.
so, go
Okay.
outside, step outside, you talk, and then, when you make your decision, just let us know. Okay?
Okay. Thank you, Judge.
Sure.
Judge, I'm gonna get on the side.
Yeah. Good morning, Mr.
Good morning, sir.
Sir, you're charged with reckless driving. You're facing 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 21st, 2025, at approximately 10 p.m., an officer was investigating a fatal motorcycle accident with emergency lights activated, and the road was shut down from both directions. Accident investigators notified dispatch of a vehicle which disregarded all marked units and drove through the accident scene, almost striking officers and record drivers at the crash site. The officer observed the vehicle traveling at a high rate of speed and cut through an Exxon service station parking lot and turned down another road. The officer followed the vehicle and initiated a traffic stop. The vehicle accelerated and began darting in and out of lanes without using a turn signal. The vehicle then turned and came to a stop. A high-risk stop was conducted and the defendant was taken into custody. A security sweep of the vehicle was conducted and the officer observed 2 baggies of a green leafy substance in plain view on the driver's side seat, known from training and experience to be marijuana. The defendant was identified by a safety driver's license, and the defendant was transported back to the accident scene, where the accident investigator confirmed the defendant's vehicle was the same vehicle that disregarded the marked patrol vehicles and disregarded the safety of the people on the scene. Other officers who witnessed the defendant's vehicle confirmed this. Deputy Chicoya advised that the defendant's vehicle almost struck multiple patrol vehicles and had approached officers while they had to abruptly move out of the way. And then Deputy Chicoya observed the defendant's vehicle almost strike 2 record drivers who were authorized to be on the scene. The record drivers confirmed this. Witness Cross advised he yelled at the vehicle to stop, and the defendant's vehicle began to accelerate faster. The defendant acknowledged he drove through a closed roadway.
Mr. Davis, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license? Please see that.
His driver's license is ineligible, Your Honor.
Mr. Davis, you are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. I don't care if Jesus comes from heaven and needs to ride to church. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Sir.
I'm going to do everything in my power to protect my community. If I find that you drive, much less drive maniacally like this, as they allege, it's not going to go well for you. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, if you do, it's not going to go well for you. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells me that you're playing games, you're not responding to phone calls, text messages, you've gone AWOL, you pick up a new case, I will revoke your bond and put you in jail. Do you understand?
Sir.
I'm not asking much. All I want my streets to be safe. That's it. I'll have you come up here, swear to us you're not going to drive. I'll get you to Victoria, sign a reset, and then you're on your way. Thanks. All right, please. All right, good morning, Mr. Gosby. Ma'am, you're charged of driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 20th, 2025, at approximately 9:24 p.m., officers observed a black Chrysler traveling southbound on Kinswood Drive, noting that the rear license plate was not illuminated, making it difficult to see, and a traffic stop was initiated. Upon activation of the emergency equipment, the motor vehicle accelerated rapidly. Based on a loud sound from the motor vehicle's exhaust and speed which it was traveling, the officer believed that the driver was attempting to elude. The motor vehicle made a sudden right turn into a private drive and continued before coming to a stop. The officer made contact with the defendant, who was the driver, and also made contact with the front passenger, who was identified. The officer observed a strong odor of marijuana. The defendant was detained due to furtive movements inside the vehicle. The officer observed multiple open container beverage vehicles, including a Four Loko and Buzzball cans in plain view in the rear passenger area. The officer observed a black bag in the front passenger seat with a 9mm handgun and a green leafy substance inside. The substance was identified as marijuana due to the officer's training and experience. The defendant admitted to possessing both the handgun and the marijuana. The officer observed slurred speech and a strong odor of an alcoholic beverage on her breath. The defendant stated that she consumed one alcoholic beverage at approximately 9 a.m. The defendant performed SFSTs. The HGN was a 6 out of 6. The walk and turn was a 7 out of 8. And the one leg stand was a 1 out of 4. The DIC was read and the defendant consented to breath, which the results were a .121 and a .116.
Any prior to DWI, and then does she have a license?
Prior DWIs, her license is eligible.
You said,
It is eligible.
right, but no prior to
No
DWI?
prior.
Okay. Mr. Ray Cosby, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, it's not going to go well. I'm telling you now, I will test you 45 to 50 days from today. If you're still using, it's not going to go well for you. Do you understand? You are not allowed to drive unless you have a valid Texas driver license and car insurance in your name. That is also a condition of your bond as well. Do you have the ability to hire a lawyer, ma'am? You want to apply for an appointed lawyer?
Yes, please.
Okay. Deputy Miranda is going to give you an application. I'll have you fill it out. I'm going to have you sign a reset Victoria, and then we'll have you take a signature box, ma'am. Please. You are Rafael Garcia. Mr. Garcia, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 23rd, 2025, the officer observed a vehicle traveling at a very high rate of speed. The officer was unable to get its exact speed, but based on his training and experience and the fact that the vehicle rapidly passed other vehicles, determined that the vehicle was well above the 35 miles per hour posted speed limit and a traffic stop was initiated. The officer made contact with the defendant, the driver, and observed an odor of an alcoholic beverage on his breath and person and watery eyes. The defendant admitted to drinking a mixed drink at a party earlier in the evening, and SFSTs were conducted. It was a 6 out of 6 on the HDN, a 0 out of 8 on the walk and turn, and a 0 out of 4 on the one leg stand. The DIC was read, but the defendant refused to provide a specimen and a blood warrant was signed.
Okay. Any prior DWIs, and does he have a license?
No prior DWIs, his license is ineligible.
Eligible.
Ineligible.
Mr. Garcia, you're not allowed to drive. You do not have a Texas driver license. That is a condition of your bond. If I find that you drive, it's not going to go well for you. Do you understand?
Yes, sir.
You're also not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
This is an affidavit that you're going to sign with me today, that you're promising me you're not going to drive. Heed this warning. If I find that you drive and you can't justify it by any means whatsoever, if I find that you do, it's really not going to go well for you. I can have a contempt hearing and you'll be facing 6 months in jail every time you drive. Do you understand? If you want to drive, go get a license, get car insurance, and I will do backflips letting you drive. But until that point, if I find that you do, get ready. Do you have the ability to hire a lawyer?
Yes, sir.
We're going to give you time. I'll have you come up here, swear to us you're not going to drive, and get you to Victoria Center reset. You'll get with pretrial, and then you're out of here. Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. This case is 143 days. You mind reading what happened, please? So you were given a general order bond. Looks like you took on, it looks like we did probable cause, I'm assuming. I found probable cause at the time. We ordered you not to drive, and then I guess went AWOL. You've now made a surety bond. So yeah, do you mind reminding me what happened, please?
On November 5th, 2025, a traffic stop was conducted on the defendant's motor vehicle after it was observed that he had expired registration. Upon contact with the defendant, the officer observed watery, bloodshot eyes and the odor of an alcoholic beverage. The defendant admitted
He's driving. Oh, I mean, this is this case,
expired.
because he just picked up a felony, I see.
Yes, it was a PC.
So I guess, yeah, go forward with this one, and then I want to know what happened in the felony. Please.
Absolutely. The defendant admitted to drinking a can of an empty Budweiser that was found on the passenger floorboard. SFSTs were conducted. It was a 2 out of 6 on the HGN, a 6 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and the defendant consented to correct, but provided unacceptable samples. The defendant then consented to blood and a blood draw was conducted. And we do have the results of that blood.
You do or do not?
We do. And it came back for 0.05 of ethanol as well as methamphetamine and amphetamine and THC.
Okay, what happened to the felony?
Yes, Your Honor.
Please.
On, there we go. On March 22nd, 2025, the officer observed a vehicle displaying a fictitious buyer's tag and a traffic stop was initiated. The defendant, the driver, provided a Texas driver's license and warrant checks, provided a Texas driver's license, and the warrant check revealed an outstanding warrant, which led to his arrest, and that would be the DWI. During the inventory search of the defendant's property at the Pasadena jail, officers found a clear zip bag containing a white crystal-like substance identified as methamphetamine, which weighed 0.87 grams.
I'm sending you now for a drug test. I want to know what, if anything, is in your system as of right now. If you fail to go test, if you fail to come back, I'm going to revoke your bond and make it so high you will have hair falling out. Do you understand, Mr. Hara? And the next time you miss court, likewise, your bond will reach the clouds. Do you understand?
Sir.
Take your seat for me. Good morning, Mr. Juarez. Sir, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 22nd, 2025, officers were dispatched at around 2 a.m. to a burglary in progress call at 2717 Stony Brook Drive, apartment number 411 in Harris County, Texas. The officer observed the defendant to be sticking his head through a broken apartment window from the outside of the apartment. The complainant stated that the defendant began banging on her door and window, trying to get inside. The complainant stated that she had no idea who the defendant is and she had never seen him before. The defendant then broke the apartment window with his right fist and appeared to be trying to get inside the apartment. The complainant stated that she was scared for her and her children, who were also inside the apartment.
And it's a mischief?
The complainant stated that the damage was $100. The officer observed the window to be broken and the defendant had cuts and blood on his right hand from breaking the window, and there was also blood on.
You were very, you're not charged with a series of felonies. Mr. Juarez, I'm going to find that there's sufficient probable cause to go forward with your case, and I'm now going to put an ankle monitor on you so I know where you are at all times, and I'm giving you a curfew. If I find that you're a danger to my community, I only have one place for you. Do you understand? You are not to consume alcohol or illegal drugs. I'm sending you now for a drug test. I want to know what, if anything, is in your system. If you fail to go test, if you fail to come back, I will revoke your bond. Do you understand? You're not to be in possession of any weapons. You're not to go anywhere near where these people live, work at all.
The court's information, there are dismissed, it looks like the complaint in all these cases live on the same street that this mischief happened on.
Any connection, you think?
The defendant did state on the scene that he believed that he was at a different apartment on Dunleavy and wanted his mom to let him inside. Explains anything.
Regardless, I'm going to send it for a test now. I want to see what, if anything, was in his system.
Here, I was just more of a
Guys, on everything, waive the fees for everything, please. I'm going to send you for a test now. Come back. Do you understand? If you don't test, if you don't come back, it's not going to go well for you. Take a seat for me. You literally pled guilty, not 10 days ago, and now you're back again. You now stand charged with the offense of fleeing a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 20th, 2025, officers were conducting an active patrol at the 15,300 block of Corona Del Mar Drive in Harris County, Texas, and observed a black GMC Sierra traveling at a high rate of speed in a residential neighborhood. The motor vehicle attempted to slow down once they noticed the marked patrol vehicle by hitting the brakes. At that point, the officer observed a defective taillight. The officer quickly turned on emergency lights and sirens to attempt a traffic stop. The motor vehicle failed to signal, making a right-hand turn and continued driving while the officer was behind the vehicle with lights and sirens. The defendant continued driving approximately half a mile at speeds ranging from 10 to 20 miles per hour in a residential neighborhood. The defendant disregarded 2 stop signs and then
How fast in the residential neighborhood, did you say?
Sorry?
How fast?
10 to 20 miles per hour. A defendant disregarded 2 stop signs and then parked his motor vehicle in front of his residence and opened the motor vehicle door. The defendant was then detained. He stated that he was coming home when asked why he did not stop and was identified by his passport.
So no license?
There is no driver's license on file.
Mr. Melendez, you're not allowed to drive. If you do not have a Texas driver license and you don't have liability insurance, you're not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. I don't care what you need to do in life. If you don't have either, both, and permission from us, do not drive. Do you understand?
Yes, sir.
Since the 10 days, you put your arms down. Since the last 10 days that you were here, what have you done to change your life? What better have you done?
So, I'm always on school. Right now, I'm doing a job, Chick-fil-A.
That is now a condition. You must do one of either, in school or a job. I'm going to appoint your lawyer today, and I'm going to bring you back in 2 weeks to see what you have done. If you've done nothing, it's not going to go well. You understand? All right. I'll have you sign a reset. I'm going to have you take a seat in the jury box. So you're on bond for an interference and a failure to ID from November. A month later, you pick up a criminal trespass. And now you pick up a 4th case, another criminal trespass. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 17th, 2025, an officer was made aware by Voyager Apartment Complex, courtesy officer that the defendant was trespassing on the property. The officer stated that he observed the defendant walking in the hallway of the property and due to previous encounters, knew the defendant to have a criminal trespass warning from the property. The defendant was detained. The defendant has had numerous criminal trespass warnings from the location and a recent arrest for criminal trespass due to being on the locations. He was identified with his Texas driver's license.
Was this the same trespass as the prior one?
Same location, Your Honor.
Same location?
Your Honor, am I able to speak for that?
No. What I'm going to do is I'm going to put an ankle monitor on you so I know where you are at all times. You're not to consume alcohol or legal drugs, and I'm also giving you a curfew. If I find that you're out in the middle of the night, if I find that you go anywhere near this, I'm going to take all your bonds now, and I will triple, quadruple. Do you understand? I'm going to protect my city at all costs. You now have 4 open cases. You have made bond on those cases. If they give you a PR bond, but I'm telling you now, you pick up a 5th case. I'm going to make your bond so high you'll have teeth falling. Do you understand?
Yes, sir.
Tell me about the interference, please.
Yes, Judge. So on November 26, 2024, an officer heard a verbal disturbance in a parking lot while patrolling on foot at an apartment complex. The officer made contact with the defendant and a female. The officer attempted to identify the defendant, who refused to identify himself and stated, "I'm not identifying myself." The officer
Same complex.
Let me check.
Yes, sir.
Stop.
Yes, Your Honor. Same complex.
I don't want you to go within 1,000 feet of this apartment complex. Do you understand?
Yes, sir.
I have a monitor that I'm going to put on your ankle today. If it dings anywhere near there, I don't care what your excuse is. It's not going to go well for you. Your cases are now from November of 24. It is way too much drama for me. So you will get a lawyer today, and in 30 days, is discovery complete on the cases from 24? It's way too much drama. I'm ready to set these off for trial.
Discovery is complete on the interference, Your Honor. And
Very
discovery
good.
is also complete for the previous criminal trespass.
Get ready. I'm fast tracking this trial, 30 days.
Yep.
So I'm gonna appoint him a lawyer today. I'm gonna have him take a seat in the jury box, have him meet with the lawyer. 30 days, it gets set for trial. You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, it won't go well for you. You understand? All right, come on. Good morning, Mr. Nguyen. You speak English?
Yeah.
Mr. Nguyen, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 21st, 2025, an officer was traveling southbound on Grand Way. The officer was driving 80 miles per hour in a 75-mile-per-hour zone. He then witnessed the defendant operating a motor vehicle pass him from the improved shoulder. The officer followed the defendant and witnessed the defendant change lanes when unsafe, drive on the shoulder, follow other vehicles too closely, drive without lights when required, and pass on a no passing zone, disregarding the safety of others.
Okay. Mr. Nguyen, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? Do you have a license? As a condition of your bond, I'm ordering you not to drive like this anymore. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
His driver's license is eligible.
You're not allowed to drive unless you have valid liability insurance as well as a Texas driver license. Do you have the ability to hire a lawyer, Mr. Nguyen? How old are you?
18.
Okay. We'll provide you a lawyer today. You will be signing bond conditions. I'm telling you now, jail sucks. At 18, if you end up going to jail, they will have a field day with you. Do you understand? I'm not asking much, but if I find that you make my streets unsafe anyway, it really will not go well for you. Okay? I'll have you sign a receipt. We'll have you. I got no more room. Okay. Deputy Miranda's going to detect you where to go. No, don't worry about it. Do not leave until you sign our bond conditions. Do you mind filing that? No reckless driving, racing, street takeovers, donuts, etc. Please. Good morning, sir. So you're charged with the offense of falsifying drug test results. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 22nd, 2025, an officer while assigned to the Harris County Toll Road Authority DWI Task Force observed a vehicle traveling 87 miles per hour in a 65-mile-per-hour zone. The officer observed a traffic stop was initiated, and the officer observed the strong odor of marijuana, and the defendant stated he personally smoked marijuana earlier that day. The defendant offered to allow the officer to search his vehicle for marijuana. The officer conducted a probable cause search of the vehicle and located a firearm. The officer also found a liquor flask-sized opaque plastic bottle in the glove box with a temperature sensing strip on the top containing a yellow liquid. The defendant stated he purchased the bottle so that he would not fail a drug test to get a job.
Any open cases?
No open cases, Your Honor.
All right, Mr. Onikidi, I'm going to find that there's sufficient probable cause to go forward with the case. Sir, do you have the ability to hire a lawyer?
I actually have a lawyer. I'm surprised it's not him.
You do have a lawyer. Let me see if any documents have been filed. Do you guys see anything? Are they going to, who, are they, you've hired them?
Yeah, I did hire them a couple of days ago.
They
said they will
told you
show
they
me.
would be here?
That's what I'm doing.
Who is?
He's from Gilligan. I don't really.
Say Gilligan?
Yeah.
I guess let's do this. I'm not going to put any conditions on your bond. Well, hold on a second. Does he have a license?
He does. It is eligible, Your Honor.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I guess I'll have you sign a reset now. We'll have you take a seat. It's still kind of early. We'll wait to see if they come. Do you have a phone number? Maybe you
can
can
I
go
call
call them and see if they'll come, and then we can address but don't leave until we excuse you, okay? All right, please.
Judge, that's state bond condition?
Yeah. You are Victor Ortiz.
Yes, Your Honor.
Mr. Ortiz, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed.
On March 20th, 2025, an officer observed a vehicle traveling with its rear license plate lamp out, making the license plate unreadable. A traffic stop was initiated. The officer made contact with the defendant, the driver, and the officer observed the strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, stumbling, and the defendant used the car for support. During an inventory search of the motor vehicle, the officer located 4 open containers, 2 empty and brown bags cold to the touch, 1 half empty, and 1 freshly open. All 4 were cold to the touch and they were 4 logos. The defendant denied drinking the alcoholic beverages and admitted to being an alcoholic, having a drinking problem, but he stated that he did not have any idea how many alcoholic beverages got into the motor vehicle. SFSTs were refused. The defendant was read the DIC and declined to provide a specimen. The defendant was arrested and a blood warrant was signed and executed.
Mr. Ortiz, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive. I don't care what's going on in your life, and you are signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, it's an offense punishable by up to 6 months in jail and a $500 fine. Do you understand?
Yes, Your Honor.
You will now get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you fail to blow into the device, if you consume alcohol, if you consume illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
If you have a problem with drugs or alcohol, you better address it. Now is the time for you to address it, because if you don't, and it becomes a problem, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am now also placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have an ignition interlock on it. We send this notice to DPS so that everybody in the entire world, or I'm sorry, all officers in Texas know that if you're driving, you must have an interlock, and if you don't, they will put you in jail.
Yes, Your Honor.
No alcohol, drugs, random testing, and the portable device. You have the ability to hire a lawyer, Mr. Ortiz.
No, Your Honor.
I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. How much money you have at the bank, what you do for a living, what kind of car you drive, and then I'll take a look to see whether you qualify. Deputy Miranda is going to give an application. I'll have you sign a reset with Victoria. You'll get with pretrial for your bond conditions, and after that, we'll take a look to see whether you qualify. Mr. Smith, you're charged with 2 cases. You're charged with possession of marijuana. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the weed case, you're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer had conducted a traffic stop for expired registration at 567 South Mason Road in Harris County, Texas. The co-defendant was taken into custody for 5 active warrants. The driver was asked to take a bag with him containing his personal items. Inside the bag, the officer contained a small white plastic bag containing multicolored chocolate pills known to be ecstasy and Xanax. The co-defendant claimed ownership of the pills. A probable cause search was conducted and officers located a handgun with ammunition located behind the driver's seat on the floor of the vehicle, a baby bottle containing promethazine cough syrup, and a clear cylindrical container of marijuana. The total weight of the ecstasy pills was 8.4 grams. The weight of the Xanax pills was 118.2 grams. The weight of the marijuana was 0.05 ounces. The weight of the promethazine cough syrup was 5.19 ounces. The defendant, the passenger in the vehicle, claimed to be the owner of the marijuana and the gun and stated that the gun fell out of his pocket and landed behind the driver's seat.
What about the magazine and all that? Who's,
Um,
was there a second gun?
no, there was just one firearm, Your Honor.
Did they charge the other gentleman?
Yes.
So how can they charge him with it?
So he took ownership of the marijuana and the firearm, the defendant. Yes. The co-defendant took ownership of the ecstasy.
I thought you
and-
said that the co-defendant said the gun fell out of his pocket.
No, the defendant said that.
Got it. Okay. All right. Mr. Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand?
Sorry.
I'm also ordering you, can you run his light? He's a driver, right?
No, he was the passenger, Your Honor.
Got it. All right. Oh my. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? Do you have the ability to hire a lawyer, sir?
I'm sorry.
I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Are you working at this time?
Yes, sir.
Okay, I need to know everything about you and I'll take a look to see whether you qualify. Do not leave until you sign our bond conditions. All right. So no contact with the co-defendant and no weapons, please.
Yes, Your Honor.